The High Court in Christchurch was packed this morning, where lengthy legal arguments were expected to be heard around why the Brenton Tarrant trial should be moved away from the city. About 80 mosque attack victims, some using crutches, as well as their supporters, packed the gallery. The accused's lawyers had both flown down from Auckland, and police sporting bushmaster rifles were stationed on both entrances to the court. Then the news came, with Justice Mander announcing the application to move the trial had been withdrawn, with no explanation given. Conan Young was in court.
Anybody doubting the importance of today's hearing and the desire of victims to see the trial held in Christchurch only needed to hear the words of John Milne, whose 14-year-old son was shot dead in the Mosque. He spoke to RNZ on his way into today's hearing.
I'm hoping that I won't have to travel away from here to attend. I'm hoping that it will be held here, where it should be held, for the people to actually record what is happening, the people, the hurt, the suffering, the pain. It must be held here. It must be.
After just 10 minutes, the hearing was over, and John Milne and the other families had been granted their wish. The accused Mosque gunman, who has pleaded not guilty to 51 charges of murder, 40 of attempted murder and 1 charge of terrorism relating to the March 15 attacks, had withdrawn his application to have his trial moved. Afterwards, one man whose daughter was badly injured in the Mosque and who can't be named for legal reasons, said he was grateful for the outcome.
Of course I am happy, otherwise I will end up travelling every court time, and that's going to be an extra cost for all the victims, and that's not just my decision, that was all the victim decisions. It's to go and meet and be in the courtroom as well.
The man was injured along with his daughter, and more than 6 months on still has to use crutches. He's determined to follow the trial all the way through to its conclusion.
Physically, I'm not prepared, but mentally, yes, I am prepared, because I want to chase that up. I want to see what's the law and how can the law can protect us and protect New Zealand later on from any act can happen in the future.
While the reasons for today's decision not to proceed with a change of venue application remain a mystery, applying to have a trial moved is par for the course for any defence, according to law professor Bill Hodge. However, whether the accused would have succeeded in such an application based on the need for an untainted jury is another matter altogether.
This was not simply a local crime affecting local people who knew everybody. It was not only a national matter, but an international matter. And you really wouldn't want people serving on a jury who knew nothing of it. That would mean that they were so, well, I don't want to be rude here, but so out of touch that I would wonder about their capacity to make a decision on such matters.
Bill Hodge says the judge would also have considered the impact moving the trial would have on victims and their supporters.
There's some default principle to have the trial as close as possible to the scene of the crime so that justice can be seen to be done. And in my view, I think the community needs to feel like they have a stake in it. And if it gets moved off to another island, people can say, well, it's remote, it doesn't have anything to do with me.
The trial is due to start on June the 2nd next year, but the case will be back in court again on December the 12th for a pre-trial call-over. Kei o te tahi ahau mō te hōtaka o te ahi, ko Conan Young tēnei.